It's a travesty of justice, a miscarriage of justice. You're a piece of I'm going to write the Iranian embassy.
At the age of 13, I was kidnapped, tortured, beaten, and sexually assaulted by people I thought I could trust.
I pray that no family and nobody has to ever endure what me and my family have gone through.
A wild scene unfolded in court when Keith Swanson, the man accused of leading police on a standoff, appeared before a judge. During the incident, Swanson fired at officers through the windows of a home. The 50-year-old was arrested following a tense SWAT standoff that lasted several hours. He fired multiple rounds from a shotgun at officers, one of whom was struck by fragments but did not require transportation to the hospital. This was the chaotic scene as Keith Swanson made his court appearance. During the probable cause hearing, he began yelling and swearing, prompting authorities to escort him out of the courtroom. Swanson is facing extremely serious charges.
In this case, the officers were dispatched out to a residence regarding a criminal mischief. There was a dispute between the defendant and his neighbors.
When police arrived at Kings Bridge near Wellington Arch, they say Swanson fired at them from inside his home, shattering a window. Fortunately, no one was struck, though an officer was injured by flying glass, but is reported to be fine.
The defendant made continual threats to fire at police officers. Because of that, he's been charged with aggravated assault of a police officer.
Police fired at Keith Swanson once, but he was not injured. SWAT teams were then called in to negotiate his surrender and coax him out of his townhome. If found guilty, the man could face a prison sentence ranging from 5 years to life. After a lengthy 6-year wait, a man found guilty of assaulting a young homeless woman finally faced his sentencing, marking a moment of long-awaited justice in Burlington, as stated by prosecutors. In May, James Burke was convicted of deceiving a 21-year-old woman into entering his home, where he committed the assault back in 2004. Since then, Burke has appeared in court numerous times, often disrupting proceedings with loud, angry outbursts, and even issuing threats toward his own legal team. True to form, he caused another scene on the day of his sentencing, launching into a verbal tirade against the judge upon learning he would spend the next 18 to 20 years in prison.
The sentence is 18 to 20 years to serve.
James Burke, infamous for his disruptive behavior in court, was escorted away in handcuffs while yelling slurs at the judge as he was led out of the courtroom.
This is a travesty of justice, a miscarriage of justice. You're a piece of I'm going to write the Iranian embassy.
In May 2004, James Burke was found guilty of assaulting a 21-year-old homeless woman after offering her a place to stay for the night. He has now been sentenced to serve the next 18 to 20 years behind bars.
This is a man who, over the course of decades, has preyed on the weak and particularly on women who were in a position of being weak.
During the proceedings, he repeatedly disrupted the judge and engaged in loud arguments with the state's attorney.
This is the most corrupt state's attorney in the country.
Prosecutors describe him as a dangerous individual who shows no regret or remorse for his actions.
He, in his own mind, does nothing wrong. It's always somebody else's fault.
Burke also has an extensive criminal history, with convictions for 17 separate offenses across 3 different states.
Not only has it affected my life, it has had catastrophic effects on my family.
Today, the victim bravely shared how the attack has left her emotionally scarred, plagued by relentless and painful flashbacks.
It's not about me anymore or about what it's done to me. That's all over the bridge. Now it's about James Burke and what he's capable of doing to people.
At the time of the 2004 assault, the maximum penalty for the crime was 20 years in prison. His conviction followed years of legal motions and delays, including a defense that challenged the accusations. However, recent changes in legislation mean that if the offense had occurred today, Burke could have been sentenced to life behind bars. A judge in Detroit has been removed from his position after defending his choice to place a young girl in handcuffs. The girl had been attending a field trip to his courtroom when the incident occurred.
Fall asleep in my courtroom one more time and put you in the back, understood? One thing you'll learn about my courtroom is that I am not a toy. I'm not to be played with.
The teenager was part of a nonprofit summer program when the incident took place. The judge involved, Kenneth King, had her escorted out of his courtroom, then instructed her to wear a jail uniform and handcuffs. However, his actions didn't end there.
I'm thinking maybe she needs to go to the juvenile detention facility. You do understand that we have a jail for kids.
So do I have any reservations? Do I think I was heavy-handed in what I did? No, I don't, because I'll do whatever it needs to be done to reach these kids to make sure that they don't end up in front of me. So that was my own version of scared straight.
Once again, the offense committed by the teen was simply dozing off. The girl's mother has expressed that the judge's actions were completely inappropriate. As a single mother facing hardships and constantly relocating with her family, she had hoped the summer program would offer her daughter a positive diversion. Unfortunately, instead of a helpful experience, her daughter is now left traumatized.
You sleep at home in your bed, not in court.
So the fact that he was talking about you go home and get in your bed, how do you know my baby got a home? How do you know my baby got a bed, her own bed that she can sleep in? She don't have that right now. So she was hired to belittle her in front of the whole world and her friends to make her even feel more worse about our situation. I'm a single mother. I'm trying my best. I'm doing everything that I can.
The chief judge of the district has announced that Judge King will be taken off his caseload while he undergoes sensitivity training. In response to the situation, Judge King claimed that he had made an effort to contact the teen's family and offered to personally mentor the girl. However, her mother declined his offer, expressing that it was not a suitable solution to the matter at hand.
While this tragedy has severely impacted my life, I would not let this define who I am and what I bring to this world. Therefore, I wish that you give Daniel Riley, the man who changed my life forever, the max that you can give so he can learn from this.
A young woman had the final word before the jury decided on the sentencing in the Daniel Riley trial, which extended into the late hours. The jury recommended a sentence of up to 19 years for Riley in a case that has captivated the nation's attention. Riley was found guilty on 4 charges, including second-degree assault, armed criminal action, and operating a vehicle without a valid license. After an emotional week of testimony, during which the young victim confronted the man she says altered her life, the jury reached its late-night decision on how long Daniel Riley should remain behind bars.
I'll never have an easy, normal life like I did before.
Tears streamed down her face as Jani Edmondson faced the 12 jurors, urging them to impose the maximum sentence on Daniel Riley, the man who caused her to endure the painful process of relearning how to walk and stand.
I pray that no family and nobody has to ever endure what me and my family have gone through.
As Daniel Riley watched in the courtroom, he learned that after 3 hours of deliberation, the jury had found him guilty on 4 charges. Jurors recommended that Riley receive a sentence of 6 years and 3 months for second-degree assault, 11 years and 8 months for armed criminal action, and 10 months for fourth-degree assault. This means Riley could face a total of up to 18 years in prison. This incident stems from the February 18, 2023 crash, which caused such catastrophic injuries that her legs had to be amputated. She was at a volleyball tournament in downtown St. Louis when the crash occurred. At the time, Riley was out on bond for a pending robbery case, despite repeatedly violating the conditions of his release.
Some things that used to be so simple, like taking a shower, I have to adjust. I now have to take showers sitting down because I have no legs.
Riley was offered the chance to testify both before and after the verdict, but he chose to decline.
My daughter was hurt so bad that day, but it could have been anyone's daughter. Could have been anyone's aunt, anyone's sister.
The mother told the jury that she wants Riley to fully grasp the impact of his actions on that tragic day.
He was reckless and abandoned that day when he took off in that car. He cared for no one but himself. He had no concern for no one, especially Janae, that night.
Daniel Riley was found not guilty on charges concerning the other driver involved in the accident. He expressed a desire to embrace his mother one last time. Later, Judge Michael Noble sentenced Daniel Riley to 18 years and 9 months in prison for causing the downtown car crash that resulted in Jani Edmondson's legs being severed. He adhered to the sentencing recommendation made by the jury after its guilty verdict. The judge also imposed the maximum fine of $500 on Riley for driving without a license and denied a motion from Riley's attorney seeking a new trial.
The sad thing about it is what you put this young lady through, in that you have brought your own 2 sons into this.
8 years later, justice was served when a Fresno County judge sentenced Sandra Garcia, the woman responsible for orchestrating a horrific crime against a young girl. Garcia was convicted last fall by a jury for the 2016 kidnapping and assault of a Fresno County teen. During the sentencing, the victim, now a young woman, spoke in court, recalling the harrowing experience as the courtroom watched in silence.
At the age of 13, I was kidnapped, tortured, beaten, and sexually assaulted by people I thought I could trust.
The Fresno County woman who was kidnapped as a young girl over 8 years ago had the final say in court, addressing Sandra Garcia, the mastermind behind the plot. Recalling the crime, the victim bravely spoke out, confronting Garcia as part of the sentencing process.
As the saying goes, if you can't do the time, don't do the crime. Thank you.
Back in February 2016, a tragic crime unfolded involving a young girl whose identity remains protected due to her status as a minor. While making her way home from school, she recounted a harrowing encounter with men dressed entirely in black. They forcibly placed her in a trunk and transported her to a secluded area in Fresno County, where, according to prosecutors, they assaulted her and abandoned her tied to a tree.
Your Honor, I plead with you to give these inhumane people their maximum sentence so that they can never do this again to me or anyone else.
Sandra Garcia was sentenced after being convicted of multiple charges, including kidnapping, torture, and sexual assault. Prosecutors revealed that Garcia was upset after being evicted from her boyfriend's residence. It is claimed that during this time, she orchestrated the plan to abduct his daughter. She recruited her 2 sons and a cousin to carry out the crime, which led to the young girl's traumatic experience. Mark Anthony Roque, his brother Brandon, and Miguel Carriedo were all convicted for their involvement in the crime. While Mark Anthony and Carriedo are still awaiting their respective sentences, Sandra Garcia has already been sentenced to life in prison without the possibility of parole.
And this act has to have been one of the most desperate, diabolical, sadistic, evil, and repugnant acts I've ever seen.
The judge wrapped up Sandra Garcia's sentencing with a brief yet pointed statement. "Goodbye, ma'am." The 48-year-old Garcia is set to be transferred to Valley State Prison in Chowchilla, where she will serve the remainder of her life sentence. A pivotal moment has emerged in a case that reignited the abortion debate in Ohio and beyond. A judge in Franklin County has sentenced Gerson Fuentes to 25 years to life in prison for the rape and impregnation of a young girl. The girl journeyed to Indiana to seek an abortion, with pro-choice advocates pointing to Ohio's restrictive laws as the driving force behind her decision. Her out-of-state abortion quickly captured national attention, becoming a major news story. At the request of the victim's family, the judge refrained from commenting on the specifics of the case. However, he did reveal that the court viewed this as one of the most heinous cases it had ever handled.
However, today, by the request of the family, this court will be sentencing without comment. And everyone knows how hard that's going to be for me, because the court considers this the worst of the offense.
Common Pleas Judge Julie Lynch used powerful words just before delivering Gerson Fuentes' sentence, life in prison, with the possibility of parole after 25 years.
Who's ever been in this courtroom for the last 20 years knows how this court feels about babies, young people being violated.
As outlined in the criminal complaint, Fuentes had sexual intercourse with the victim on 2 occasions. At the time, the girl was very young and the daughter of his girlfriend. The Franklin County prosecutor explained that the victim's mother took her to a doctor after the girl expressed feeling fatigued. A pregnancy test was administered and the result was positive. By June 30th, 2022, the mother and daughter made their way to Indianapolis for an abortion. Shortly after, the Columbus Police Department traveled to Indianapolis to gather evidence.
On July 2nd, members from the Columbus Police Department traveled to the hospital in Indianapolis to retrieve the products of conception, is what they're called, and then submit them as evidence for comparative DNA analysis.
In court, the prosecution detailed how police collected DNA from the young girl at her home in Columbus. Additionally, DNA samples were taken from all the men residing in the household, including Fuentes. He later confessed to his terrible actions involving the girl.
The state has been in contact with the mother of the child and that she is not objecting to this plea or to this resolution.
In court, Fuentes pleaded guilt to 2 charges of raping a victim who was young, which meant he forfeited his right to a trial. As a result, he is now facing a life sentence. Fuentes chose not to make a statement during the proceedings. He will be eligible for parole after serving 25 years.
We, the jury in this case, do find defendant Terrence Green guilty of rape.
Terrence Green, a former dance teacher at the Cleveland School of the Arts, was convicted of 65 charges, including rape, sexual battery, and kidnapping, for abusing 8 students over a span of 2 decades. These offenses occurred from 1998 to 2019, both on and off school premises. The victims reported their abuse in 2020, leading to his arrest and eventual conviction.
Imagine having your mentor betray you and treat you like that.
The lawyer representing the victims, now in their 20s and 30s, describes the ruling as a long-awaited form of justice.
I think they're relieved. I think this really gives them some closure.
Ryan Fisher, the lawyer who represented the victims in a civil lawsuit against the school, revealed that the Cleveland Metropolitan School District reached a $3.25 million settlement with the victims in 2021. Green, a highly regarded dance instructor, was instrumental in launching the careers of numerous young dancers, some of whom went on to perform on Broadway. He also later worked at Tri-C's Dance Academy for Children, where prosecutors alleged the abuse persisted.
He left Cleveland School of the Arts and got a job at Tri-C. And he repeated his behavior at Tri-C.
Fisher filed an additional lawsuit against Tri-C on behalf of one of the accusers, alleging that the school's background check on Green flagged a red X for student-related allegations, yet Tri-C still hired him negligently. Nobody bothered to review the background report before hiring him, Fisher stated. However, regardless of the results of the civil cases, the victims emphasize that this particular court decision is the one that truly matters to them.
They're relieved. All of them were concerned that he was going to go out there and do this again to somebody else.
Terrence Green was convicted on 65 charges, including 16 counts of rape, 25 counts of sexual battery, and 13 counts of kidnapping for abusing 8 students over a span of 21 years. He was sentenced to life in prison with the possibility of parole after 365 years. The judge also labeled him a sexually violent predator, acknowledging the long-lasting impact of his actions on the victims. Anton Harris, known as the medical center rapist, was sentenced to 99 years in prison after being convicted of raping and robbing victims in nursing or medical center apartments. The jury took just over 2 hours to reach the decision. Harris's crimes were recognized as particularly heinous, and his sentence reflects the severity of his offenses. During closing arguments, prosecutors emphasized the emotional trauma suffered by the victims as they urged the jury to consider it when deliberating Anton Harris's sentence. They argued that the lasting impact of his crimes warranted a severe and lengthy punishment.
The victims of Anton Harris have been shattered.
Though Anton Harris was convicted of only 1 rape, prosecutor Elena Altis referenced 4 additional rape cases for which Harris had been indicted. During the punishment phase of his trial, the victims of those cases testified. One of the victims, accompanied by her service dog, which she has had since the attack, was present in court during the sentencing phase.
The defendant has sentenced each one of those women that you heard testify to a life sentence. And he deserves a life sentence.
Harris's lawyer argued for a sentence less severe than life in prison, suggesting that 30 years would be a more appropriate punishment. He urged the jury to show mercy, implying that a lengthy but not life-ending sentence would be sufficient.
We should not rush and throw away the key and just say, forget about it.
What we are going to respectfully ask is that you assess a sentence of 30 years prison.
The jury clearly rejected the defense's plea for mercy. Harris was sentenced to 99 years for the aggravated sexual assault case and 60 years for the aggravated robbery charge, with both sentences to run concurrently. This means he will serve both terms simultaneously, but he won't be eligible for parole until he has served 44 years in prison, ensuring that he remains incarcerated for a significant portion of his life before potentially being considered for release. A man facing charges for raping a young girl was prepared to enter a plea of no contest, a decision that both the prosecution and defense supported, believing it would spare the family additional suffering. However, the judge's unexpected move shocked everyone involved. Had the judge approved the plea deal, Ralph Maestas would have been sentenced to 30 years in prison. Now, instead of that outcome, he's heading to trial, where he faces the possibility of a much longer sentence. This plea agreement, which both sides had been negotiating for years, seemed like a way to secure a lengthy prison sentence for the accused child offender. But now, Ralph Maestas' future remains uncertain after the judge turned down his no contest plea.
I've never seen it occur like this in all my years of practice.
It wasn't only the defense that was taken by surprise.
I was told that this was going to be a hearing about the plea and not the sentencing. And
I don't understand the rationale. Can you explain, please?
I made my decision. I am rejecting this repeat offense.
Judge Samuel Weir did not provide an explanation for rejecting the plea agreement that would have sentenced Maestas to 24 to 30 years in prison. The 25-year-old stands accused of violently raping his girlfriend's daughter in 2009. Maestas was arrested 8 months later when the girl's older sister revealed to her therapist that she had witnessed the assault. As the case now heads to trial, that sister may be called to testify, a situation neither side is eager to face.
There are a number of very horrific details in all kinds of ways. It's going to put the victim's family back through all of this.
If found guilty at trial, Maestas could face a life sentence, along with an additional 77 years in prison. When we reached out to Judge Weir for an explanation about why he rejected the plea deal, he responded with a simple, no comment. The girl's mother told police that following the assault, she noticed her daughter was bleeding. However, rather than calling 911, she placed the girl in the bathtub to avoid an ambulance bill. Despite this, no charges were filed against her. The case has sparked widespread outrage. A severely malnourished girl was discovered locked in a closet, and Jacole Prince is now facing charges of first-degree assault, child abuse, and endangering the welfare of her child. In June 2012, the girl, who weighed only 32 pounds, was found in dire condition. The child told authorities that the closet served as both her bedroom and bathroom. The lawyers in the case are presenting the evidence from two entirely different perspectives following the girl's discovery, which was prompted by a hotline call to Children's Services.
That caller reported that there was a little girl being kept locked in a closet at 1318 Highland. Why would a parent lock their child in a closet? The answer is mental illness. This case is about mental disease.
Two younger girls also resided in the apartment along with their father. Marcus Benson had pleaded guilty to abuse 3 years ago and received probation, but he is now serving time in a St. Joe prison for violating his probation. The little girl shared with investigators the reasons behind her being kept in the closet. A woman charged in connection with a carjacking in South Memphis over the weekend made her appearance in court. 21-year-old Asia Shell faced charges including carjacking, aggravated robbery, and contributing to the delinquency of a minor, as a boy was reportedly involved. Shell stood before the judge and did not seem pleased to be in the spotlight. She expressed her displeasure with a single finger gesture, quickly followed by a double one. There was also some back and forth between Shell and the judge.
You're shaking your head. No, that's not the way to do this.
Asia Shell, who was recently arrested on theft charges and granted bond, failed to appear for her court date, leading the judge to issue arrest warrants for her. Despite being a wanted woman, Shell is now accused of collaborating with a minor to rob a man at a gas station located on Elvis Presley Boulevard. Investigators report that the 21-year-old, along with her teenage accomplice, confronted the victim while he was filling up his gas tank. Armed with a rifle, the pair demanded the victim's keys and drove off in his Jeep. While police have kept details of the investigation scarce, there's a possibility that surveillance cameras may have aided detectives in their work. Several hours after the carjacking, authorities located Shell and her accomplice hiding in a storage shed. In court, although a public defender had been appointed previously, it remains unclear who will represent Shell in the new charges. Shell informed the court that a friend guy was in the process of hiring an attorney for her.
Now, are you asking me to hold off appointing a lawyer for you, and so you can talk to your guy friend.
Asia Shell is heading back to lockup, but not before once again showing a defiant gesture. There is no clear indication that the juvenile involved in the carjacking with Asia Shell will be charged as an adult. Details about her trial proceedings and any subsequent sentencing have not been disclosed yet. Zion Foster, a vibrant girl from East Point, Michigan, was last seen on January 4th, 2022. That evening, she left her home after telling her mother, Sierra Milton, that she would spend time with her cousin, Jalen Brazier. Brazier, whom Zion trusted deeply, picked her up with plans to smoke marijuana together. Later that night, Zion texted her mother, saying she was on her way home, but she never arrived. As hours passed with no word from Zion, Milton grew increasingly anxious. Her phone's last pinged location led to an area near Brazier's home in Detroit, prompting Milton to contact the authorities.
When the prosecutor asked you what type of relationship that Zion and Jalen had, you kind of hesitated and asked him to rephrase. Remember that?
Yes.
Okay. But isn't it true that Zion, and you knew that Zion referred to Jalen as her favorite cousin, correct?
Yes.
Okay. So you do know the relationship, the extent of the relationship, correct?
Yes.
Okay.
Back on January 4th, 2022, is it fair to say you had an understanding that the defendant was the one that picked her up based on your discussions with Zion?
Yes.
Okay. And you had testified previously that you had previously had direct interactions with the defendant when he picked her up on other occasions. Is that correct?
Yes.
On those other occasions, did you see what type of car he was driving?
Yes.
What type of car was it?
The white Acura.
And what type of class of car?
When police questioned Brazier, he denied seeing Zion, claiming he hadn't been in contact with her for years. Surveillance footage quickly disproven this story, showing Brazier picking Zion up from her home the night of her disappearance. Despite the evidence, he maintained his denial. Zion's family, desperate for answers, conducted their own search in the area surrounding Brazier's home, searching abandoned buildings and dumpsters, but they found no trace of her. 2 weeks later, Brazier turned himself in and admitted to being with Zion the night she disappeared. According to his confession, Zion passed out while they were smoking marijuana. Brazier claimed he panicked, checked her pulse, and, believing she was dead, left her body in Highland Park. A massive search was launched at a Macomb County landfill. For months, investigators sifted through the landfill, but Zion's body was never recovered, and the search was eventually called off in October 2022.
One, I did turn myself in. Yes, I lied, but I was not in the right state of mind. There was no way for me to prepare for a situation like that. I was scared.
I'm not totally clear on the situation. And the report is rather sketchy with respect to the situation.
And I will fill Your Honor in on some of those details.
I appreciate it. But what the report suggests is that you had contact with the individual. The police questioned you regarding that contact. You didn't tell them the truth associated with the contact. Then you, once confronted with information that you were not telling the truth, you came forward and told them that you disposed of the body. I mean, that's all. That leaves a whole lot out there that's unaccounted for from the court's perspective. But what circumstances are you talking about?
Well, when she died, it was just random. From my end of it.
What do you mean?
I was terrified. Literally from that point on, I didn't know what to do. I wasn't in the right state of mind for anything. And I turned myself in. They didn't present me with anything. After getting my thoughts together.
So did you explain how she passed?
I don't know exactly how she passed, what caused her to pass. I just know 1 minute she was cool, she was fine, she laid back for a minute. Next thing I know, she was dead. I don't know what caused it. I did not cause it or anything like that. I reacted stupidly off of fear and panic like I've never felt before in my life. Literally.
Well, I mean, people are sitting around and somebody just passes. I mean, did you think about calling 911 or something like that?
No, not at the time. We were smoking. We were on marijuana as well, so my mental state wasn't in any like logical spectrum. I was just immediately just terrified.
During Brazier's trial, testimony from key witnesses painted a disturbing picture of Zion's final hours. One of the most critical testimonies came from her boyfriend, Vertez Gonzalez, who recounted their interactions leading up to her disappearance. Gonzalez testified that he and Zion had spoken throughout the day on January 4th, 2022, while she was at work. That evening, Zion mentioned she would be with her favorite cousin, a decision that concerned him. Later, during one of their phone calls, Gonzalez heard another voice in the background, which he recognized as Brazier's. Feeling uneasy, Gonzalez used the location sharing feature on their phones to check Zion's whereabouts. At 11:24 p.m., he took a screenshot showing her phone near Greenfield and another street in Detroit, a location later presented as evidence in court. Their last exchange occurred shortly before 1 a.m. on January 5th, 2022, when Zion texted Gonzalez saying, OMW. Gonzalez tried to reach her again later, but his calls went straight to voicemail. Growing increasingly worried, he texted her at 1:21 a.m., expressing frustration that her phone appeared to have died. When Zion failed to respond, Gonzalez reached out to her brother and even contacted Brazier directly. Brazier denied being with Zion or knowing her whereabouts. Gonzalez also recounted a failed FaceTime attempt, during which Zion sent him a screenshot at 12:09 a.m. to validate her call. His testimony painted a picture of his growing anxiety as he realized something was terribly wrong.
Is it fair to say there's a series of messages that you sent to Zion starting at about 10:52 p.m. on January 4th?
Yes.
And
yes.
Starting with 1:40, and I'm just going to put this on the screen also, could you read what the messages contained in 1:40 is?
I said, I do not want to be on the phone. I don't want to be on the phone when you're with your cousin. I told her I had that shit weird. I want you to have your time. I just want to make sure. I said, I want you to have your time. I meant to say I want you to confirm it with him, basically.
Okay, and then how about 144? What's the message?
I said, I heard bro voice is cool. Like, confirm it. I know it.
And so I guess help us understand the context here of you sending these messages to Zion at that time.
I think she wanted me to stay on the phone with her at the time. And I didn't want to be on the phone. I just wanted to make sure she was getting in the car with what she said she was getting in the car with at the time. And I knew his voice already, so I just took say I don't want to be on the phone.
Okay. And I want you to look at number 150. I believe that's going to be at the top of the next page.
Yeah.
And is that an incoming message you received from Zion?
Yes.
And what's the time reflected there on that message?
11:16
p.m.
Yeah, yes, p.m.
And what did Zion say to you in that message?
She said here.
What did you understand that to mean at that time?
That she made it to her location.
Okay. If you can go down to 179. It's going to be at the bottom of page 19.
Mm-hmm. Okay.
So, did you send her the message, I guess, reflected in number 179?
Yeah, I said, what time you going home?
Okay. And what time was that you sent it?
At 12:03 a.m. January 5th. Yeah.
And if you go down to 180, the very next message, what response did you receive back?
We finna smoke again.
Okay. And what time was that at?
At 12:03 a.m.
Okay. And then I want you to look at 183. At that time, did she send you a picture?
Yes.
And would that be the same screenshot that we discussed that's Exhibit 10?
Yes.
The screenshot of the attempted FaceTime call?
Yes.
Okay. And again, what time is that at?
Does she FaceTime? 12:09.
12:09 a.m. And that'd be January 5th?
prosecutors presented additional evidence of Brazier's inappropriate behavior towards Zion, including text messages. They highlighted his searches for terms like, "Are trash trucks also compactors?" and "What is the force of a garbage truck compactor?" Prosecutor Ryan Elsey argued that Zion's rejection of Brazier's sexual advances on the night of her disappearance led to her death. Brazier's ex-girlfriend, Katrina Smith, also testified, recounting messages Brazier sent her from prison. These included searches about landfill investigations and whether someone could be charged with murder without a body.
On January 4th, 2022, defendant picked up Zion Foster from her home and brought her to his home. He even went so far as to tell police that Ms. Foster had a habit of running away because he had a poor relationship with her mother. While the defendant was incarcerated for lying to a peace officer, he used a prohibited cell phone to communicate with the mother of his children and ask her to do legal research on his behalf. He wanted to know whether someone could be charged with murder if a body was never found. While incarcerated, he used other inmates' phone accounts and advised his girlfriend not to show up to court proceedings. The defendant reset his phone to wipe it clean and hide his crimes. He advised police Ms. Foster died as a result of a marijuana overdose. Later, he told police that the victim died because of an LSD overdose. Finally, he returned to his original story that Zion Foster died as the result of a marijuana overdose. For all these reasons, this court finds that OV-19 does not adequately address the particular facts in this case.
The defense maintained that Zion's death was accidental, possibly caused by a medical condition worsened by marijuana use. Brazier's attorney argued that his actions afterward, disposing of her body, stemmed from panic and fear, not malice. However, the prosecution countered with evidence of Brazier's shifting stories and repeated lies, which they said were attempts to cover up his crime.
This case illustrates that the defendant has no concern for anyone other than himself, including his closest family members. All of these facts lead this court to believe that the defendant has a poor chance for rehabilitation. As such, to ensure the protection of the community, a sentence that is longer than contemplated by the sentencing guidelines is warranted and necessary. Fourth, consecutive sentences are also appropriate in this case. The tampering involved the body of Zion Foster. The jury verdict reflects that it concluded that defendant disposed of the victim's body to conceal the way that he killed her, as well as to conceal the fact that he had killed her. The effort was followed by a torrent of lies to Ms. Foster's family and law enforcement. Defendant's admission that he disposed of Zion Foster's body to police weeks after her murder was part of an ill-conceived attempt to avoid taking responsibility for Zion Foster's death, especially considering his changing stories about the cause of her death. So for these reasons, the defendant is sentenced to 38 to 90 years with a consecutive sentence of 5 to 10 years on count 2 with credit for 356 days served. You're to pay a crime victim's assessment in the amount of $130. You're to pay court costs in the amount of $1,300. The State Court Administrator's Office has determined that $1,300 is the average cost of this court if a case proceeds through it, and it covers salaries and benefits for court personnel, goods and services necessary for the operation of the court, and necessary expenses for the operation and maintenance of court buildings and facilities.
After just 30 minutes of deliberation, the jury returned with a guilty verdict for second-degree murder and tampering with evidence. Zion's mother, who had fought tirelessly for justice, wept as the verdict was read. During sentencing, Judge Donald Knapp handed Brazier a consecutive sentence of 38 to 90 years for the murder and 5 to 10 years for tampering, emphasizing Brazier's betrayal of Zion's trust and his lack of remorse. Though Zion's body was never found, her family found solace in the conviction, with her mother stating, "You thought she didn't matter to us. You were mistaken. Good riddance." On the evening of July 1st, 2019, an altercation at a Marathon gas station on Irwinton Road in Macon, Georgia, escalated into a fatal encounter. The incident began when 40-year-old Lamegia Willis and 21-year-old Clintavious Mister crossed paths at the station. Witnesses later testified that the confrontation stemmed from a dispute, with Willis accusing Mr. of stealing $10 worth of marijuana and other items, including a gun and expensive sneakers, in a prior alleged theft. As Willis pulled up to the gas pumps to refuel his girlfriend's car, he encountered Mr., who was shirtless and appeared prepared for a fight. Words were exchanged between the two, with witnesses hearing Willis declare, "I don't fight, I shoot." Despite the heated exchange, Willis had the opportunity to leave or de-escalate the situation, but instead chose to retrieve a .40 caliber pistol from his black pickup truck. According to security footage, Willis, armed and deliberate, strode across the parking lot toward Mr. In a matter of seconds, he raised his gun and shot Mr. at point-blank range. Mr. collapsed immediately. The incident was captured on surveillance video.
So at this point, you were afraid that they were going to go to your girlfriend's house and kill her?
And me too, and the kids. So that's when I came around the car with a gun in my hand, hoping that he would run or back down, because I'm scared of him. I don't know what. Nobody, everybody out there laughing and they ready for it to go down. No, need to hear everybody laughing like it's a game. Everybody got phones out. Nobody's calling the police. Nobody.
Were you under the impression at this point that at least one of them had a firearm on them?
Yes. When I know Mr. Campbell, when he asked him, "If we good, man, I ain't gonna let it go down like that," I knew he had a gun. That's why after it happened, everybody scattered. I know they had a gun. They didn't come. If I said I was going to shoot them, don't you think anybody in their right mind would have left in? They were still amping the situation up and laughing about the situation like it was a game.
So what did you do after you shot Mr.
This truck found, put it in there, went in the store, and told the clerk that I had just shot somebody and called 911.
And you asked the clerk to call 911 because you didn't know about it?
Yes.
And what did you do next?
I went back out to the car, and I heard everybody come out, "Yeah, man. Yeah, man. He don't try that, man. Man, ain't shot my homeboy." And that's when I seen Mr. And he was like, "Man, I want to go. Take you home, man. I ain't come up here for this. Take me home."
Did you take him home?
Yes, I got scared. He jumped in the car and left.
Willis testified during his trial that he acted in self-defense, claiming that he feared for his life. He alleged that Mr. had threatened to harm his family and that he believed Mr.'s companion might have been armed. However, Mattson dismantled this narrative during cross-examination, pointing out inconsistencies in Willis's story and his actions following the shooting. For instance, Willis was seen putting the gun back in his girlfriend's car before entering the store unarmed, contradicting his claim that he felt threatened.
Even with a firearm.
But I know they had one because they was talking about it. You keep saying that they didn't have a firearm. They were sitting there having a conversation about having a firearm. They're not going to come in this court and tell the truth. Their life is not up. Mine is.
Okay, but Alicia Jackson came in this courtroom and she said she didn't hear anything about them having a firearm. She didn't see them have a firearm. In fact, she told this jury that she didn't hear him threaten you at all.
No, did she tell you that she told her friend that with her, "Hey, I'm finna watch this sexy nigga done took his shirt off. I'm finna watch him out the old nigga out." Did she tell you that?
Oh, you heard her say that?
Yes, I did.
Oh, okay.
Yes. They was over there laughing and joking. Everything was a joke to everybody.
Mr. Willis, you're so scared for your life, but you've heard all kinds of stuff out there that everybody else hadn't heard. But all you can think in your mind is you're scared for your life. Where did you get hit?
What, when he pushed me?
Huh?
What, when he pushed me?
Yeah, where did you get hit?
In the chest area with the door, when he pushed the door.
Huh?
When he pushed the door in my chest.
So did he lay a hand on you?
Pushed the door.
My question to you, Mr. Willis, is the contagious Mr. lay one single finger on you?
Technically, no, but he caused the door to hit me when he pushed me. The dog said he pushed me, he pushed the door. The door, yes. Technically, yes, he laid a hand on me.
Okay. He will touch you?
I didn't let him get close enough to punch me. I was cool, evading him. Like when I was at the gas pump and he walked
So when you walk at least 10 feet with that firearm shooting in the head, you're evading him?
No, that's when you ready to watch me.
No, that's when you decided, I'm fixing to put a bullet in his head.
In court, Willis expressed remorse, stating, "I'm sorry that he died, and I'm just sorry." He claimed that he fled the scene out of fear and did not turn himself in for 2 days because his lawyer was unavailable, and he believed the police were prepared to shoot him on sight, an unsubstantiated claim. Despite his emotional testimony, Willis's explanation failed to convince the jury. The surveillance footage played a pivotal role in the trial, leaving no doubt about the calculated nature of Willis's actions. Mister's mother, Debbie Mister, gave a heartfelt statement during the trial, mourning the senseless loss of her son, who had been a beloved figure in his community. Known for his athleticism and kind spirit, Clintavious Mister's life was tragically cut short over a petty dispute. Debbie described how the loss had upended her life, leaving her unable to return to the home where she raised her son. The trial, which included Willis's 45-minute testimony, ended in a Bibb County Superior Court jury convicting Willis of malice murder, felony murder, aggravated assault, and possession of a firearm during the commission of a felony. After just 37 minutes of deliberation, the jury returned a guilty verdict. Judge Howard Z. Sims sentenced Willis to life in prison, stating, "This wasn't self-defense. This was absolutely brutal, Mr. Willis. It was outright sidewalk execution." Jack Crawley's story is one of chilling violence and calculated actions that left two families in anguish. At just 19 years old, Crawley committed crimes that shocked communities across Scotland and England. The tragic chain of events began in October 2023 when Paul Taylor, a 56-year-old Army veteran and father from Annan, Scotland, disappeared during a trip south to Carlisle. Unknown to his family, Taylor had arranged to meet Crawley for a consensual encounter. Crawley came prepared, and once the two were alone in a remote area near Carlisle, he launched an attack, striking Taylor. Crawley's intention was not only to kill, but to steal Taylor's car, a Vauxhall Corsa, which he hoped to sell. After the murder, Crawley went to great lengths to cover his tracks. He moved Taylor's body to a wooded area and then concealed the remains in dense underbrush. Days later, Crawley carefully cleaned the car, removing bloodstains, and advertised it for sale. However, his plans unraveled when he crashed the car and abandoned it in Langwathby.
18th of October last year, Paul Taylor, a 56-year-old man who lived with his family in Annan, drove to Carlisle after you had agreed to meet him for the purposes of consensual sex in a remote place near Carlisle. You knew Mr. Taylor because you'd met him for similar purposes many times before. This time, however, you took a hammer with you, which you used to strike him with heavy blows to the head and face at least 10 times. Once you were sure he was dead, you put his body in the boot of his car and drove to another remote place, Finlandrig Woods. There you made a fire and burnt the body before dragging the remains into bushes and trees to hide what you'd done.
Following his arrest, Crawley refused to cooperate with police and was released on bail. Instead of complying with his bail conditions, he fled across Scotland and northern England, evading authorities for months. While in York in January 2024, Crawley repeated his violent pattern. He met another man through a dating app and lured him to a secluded area. This time, Crawley attacked his victim with a hammer, intending to kill him. The man fought back, disarming Crawley and forcing him to flee. In the aftermath, Crawley burglarized a home to steal clothing before being arrested in Bath in February. At the time of his arrest, Crawley was found with a knife and cannabis in his possession.
You were arrested and interviewed by the police. When you told them nothing, you were released on bail with conditions of residence and reporting to the police in Carlisle. Quickly you left, travelling to Glasgow, Aberdeen and Edinburgh before you arrived in York. When you arrived in that city, you bought another hammer. And on the 5th of January this year, you arranged to meet another older man again for consensual sex. Picked you up in his car at an agreed meeting place, and then you drove together to a remote place near Acaster-Malbis. Whilst alone together, and as he was performing a sexual act on you, he was struck to the head, face and arm by you with a hammer. He fought back and managed to take that hammer away and threatened you. At that point you ran away, later committing a dwelling house burglary offence when you stole clothing. lesser wounds to the face and head, your intention, as the jury has found correctly in my judgment, was to kill him. It was not until the 2nd of February this year that you were further arrested in the city of Bath, whilst you were in possession of a knife and cannabis.
It wasn't until May that Crawley finally disclosed the location of Paul Taylor's body to his solicitors. The remains were found in Finglandrig Wood. The delay in discovering the body added to the suffering of Taylor's family, who had spent months searching for him, clinging to hope.
It was your evidence in the trial that your motive for your attack upon Mr. Taylor was to steal his car, although you claimed that you did not intend to kill him. That defense was rejected correctly by the jury. But I'm sure that your motive for attacking Mr. Taylor was for gain, to steal his car. After killing him, you made efforts thoroughly to clean the car, to remove as much of the blood staining you could, and later you tried to sell it for £2,000. Before you could do so, you crashed the car and abandoned it.
During the trial at Carlisle Crown Court, Crawley admitted to manslaughter but denied murder, claiming that Taylor's death was the result of a failed car theft. The jury, however, found his defense unconvincing. The prosecution presented overwhelming evidence, including phone data, CCTV footage, and forensic findings that revealed Crawley's deliberate and premeditated actions. The court also heard of the devastating impact on Taylor's family, who described him as a loving husband and father whose life was senselessly taken.
In your childhood, you witnessed your parents' divorce when you were 12, and some violence in the home by your father against you. You told Dr. Nadkarni that you were often bullied in school, and by the age of 14 or 15, you became involved in gang-related crime and drug dealing. You also told Dr. Nadkarni, as you told the jury, that you were under threat from a drug-dealing gang who required you to commit drugs offences as well as burglary and theft when you committed these offences. You said that they told you to steal a car, which is why you went to meet Paul Taylor, and that they were following you as you escaped to Scotland and then to York. Whether that's true or not, I find that it provides little, if any, mitigation for these serious offences. You were not being asked to use violence, still less to...
Carlisle had a history of troubled behavior stemming from a riotous childhood. Reports suggested he had witnessed violence in his home, was involved in gang-related activity as a teenager, and struggled with PTSD. By October 2023, Crawley's actions escalated into violent crimes that would devastate families and communities. The judge, Mr. Justice Goose, described Crawley's actions as cruel and violent. He emphasized the calculated nature of Crawley's crimes, from the premeditated attack on Taylor to the attempted murder in York. Crawley's attempts to evade justice and his lack of remorse only deepened the court's condemnation.
I concluded that your minimum term in custody must be 37 years. Stand up, Jack Crawley. On count 1, murder, I sentence you to custody for life with a minimum term of 36 years and 104 days, which is 37 years less the time you served on remand of 261 days. On count 3, attempted murder, I sentence you to a concurrent term of custody for 15 years. On count 6 and 7, for the offences of burglary and possession of an offensive weapon, concurrent sentences of 4 months custody each. Finally, you must also pay the statutory charge in the appropriate amount.
Crawley was sentenced to life imprisonment with a minimum term of 37 years for the murder of Paul Taylor. Additionally, he received a concurrent 15-year sentence for attempted murder in York and further sentences for burglary and possession of an offensive weapon. The sentences ensured that Crawley would remain under supervision for the rest of his life, with parole only granted if deemed safe. The tragic case of the murder of a boy, Dylann Robinson, by his mother, Christina Robinson, unfolded as a tale of cruelty and neglect. The court convicted the mother of murder and multiple counts of cruelty. In 2022, the mother lived with her 2 sons in Durham while her husband was away for military training. During this time, she bore sole responsibility for caring for her sons, a responsibility she failed in devastating ways. The series of events leading to the death of her son began in October 2022. On October 19th, 13th, Dylann was subjected to abuse by his mother. The boy suffered severe burns. She did not seek immediate medical attention. Instead, she attempted to treat the burns with inadequate remedies purchased online, prioritizing her fear of being held accountable over her son's welfare.
For long enough to cause the dreadful injuries we saw in the photographs, you must have known that that water was extremely hot. That must have been obvious to you as you ran the water. But in any event, any decent parent would always check the temperature of the water before putting their child into it, and would never press him down into hot water, as I find you did. I find as a fact that you were angry with Dylann, whether because of the soiling or for some other reason, and you put him into that scalding hot water deliberately to punish him. The result was the appalling burns of which we've seen images. Those events were the subject of count 3. Unsurprisingly, Dylann screamed out in pain from the moment he was immersed in the water. The burns he suffered covered almost 20% of his body, including his buttocks, scrotum and penis, the back of his thighs and the back of his calves. Some burns were full thickness or near to it, others more superficial. All would have been intensely painful, both at the time and for the days that followed. As you subsequently admitted, you ought immediately to have called for emergency medical assistance, but you did not do so. You were more worried about what would happen to you if you reported his injuries. So you decided to treat him yourself with materials you purchased online. That treatment was wholly inadequate and provided little of the therapeutic benefits which he would have received if treated in hospital. That continued to be the position.
In the weeks that followed, the abuse escalated. Despite Dwelania's serious injuries, she beat him as punishment for minor behaviors she deemed unacceptable. On several occasions, she left her 2 sons unsupervised for extended periods while she went shopping or attended appointments, further endangering their safety.
You were a follower of a religious group known as the Black Hebrew Israelites, and you would listen to lectures or sermons from the group's speakers on YouTube. Mistakenly, as you subsequently admitted was the case, you took the teaching of that group to indicate that it was appropriate to punish your children, aged 2 and 3, by beating them with a bamboo cane. You did that to Dylann repeatedly, and with sufficient force to inflict the patterned tramline bruising to numerous areas of his body, which were shown in the photographs. Those injuries were deliberately inflicted at a time when Dylann was already seriously injured from the burns I have already described. Those beatings were all administered as punishments for behaviour that was objectively trivial, but which you considered worthy of severe punishment. What must have gone through the mind of this little boy, being beaten with a cane by his mother, despite these terrible burns, does not bear thinking about. That was the subject matter of count 4. The mistreatment of Dylann went beyond the infliction of these physical injuries. You also appear to regard it as perfectly acceptable to leave your children on their own, entirely unsupervised for lengthy periods, whilst you went shopping or visited your doctor. The jury found you guilty of repeated acts of abandonment.
On November 5th, 2022, she shook Dylann forcefully and repeatedly, causing brain injuries. It is believed that his head may have been struck during the assault. He succumbed to these injuries within hours. The court found that while she did not intend to kill her son, she did intend to cause him serious harm.
You did not intend to kill him. There is no doubt that your mistreatment of your son over the 17 days leading up to his death was appalling in the highest degree. The callousness of your behaviour was well illustrated, in my view, by the text exchange between you and your boyfriend, Innocent, on the 28th of October, so some 9 days after Dylann had suffered the dreadful to the bottom half of his body. You discovered that Dwellania had accessed some of your tablets during the night and had vomited on the floor. You texted your boyfriends saying that behaviour by Dwellania deserved, quote, major ass kicking, close quotes. Innocent replied, quote, come on, Chris, he's a child. Just tell him not to do it again, close quotes. Your reply included the following, quote, he's old enough to know better, so he'll pay, close quotes. When Innocent told you to be gentle, your chilling reply was, quote, he'll get what he deserves, no more, no less.
Throughout the trial, evidence of the mother's cruel and callous behavior came to light, including text messages to her boyfriend that revealed her harsh attitude toward her son.
The appropriate increase to reflect the other offending is 6 years, taking the total to 28 years. I must then make allowance for your mitigation and for totality. The mitigation available to you is that you intended really serious harm to Dwellania, but not his death, and that you had no previous convictions before these incidents. I then stand back and consider what sentence is just and proportionate as a whole, reflecting all your offending behaviour, the overall harm, your overall culpability, and all the aggravating and mitigating factors relating both to you personally and to the offences. On that basis, I deduct a total of 3 years to reflect the 2 mitigating factors to which I have referred and totality. Miss Robinson, stand up. For the offence of murder, you will go to prison for life. The minimum term you will serve before you become eligible to apply for parole will be 25 years. You can go down.
Despite the grievous nature of her actions, some mitigating factors were considered during sentencing. She had no prior criminal convictions, and the court accepted that she did not intend to kill her son. Nonetheless, the judge determined that the severity of her offenses warranted a life sentence, with a minimum term of 25 years before eligibility for parole. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.